Welcome to another episode of Mazars COVID Talks, a podcast about pandemic resilience aimed at supporting business survival by directing organizations to resources and embedding a culture of preparedness. My name is Tashonda Hagebrook, and today is May 8th. We are in May. I'm a senior consultant here at Mazars USA, joined by my co-host, Alicia.
Hi, everyone. I'm Alicia Jernak. I'm a senior manager in our entrepreneurial business services and advisory group.
And we are super excited about our guest today. We are joined by two senior partners from Becker Legal, Anthony Vizzoni and Joseph Harraka. And Joe is he's a senior partner, as I said, at the firm's litigation department. Joe's been practicing law for 35 years and has both a JD and MBA degree. And I have to say this part since Joe shared it with us. He prides himself in not only being a zealous legal advocate for his clients, but partnering with them to ensure that any recommendations that he makes are consistent with their long-term business goals and financial and economic objectives. So ultimately, Joe just becomes your best friend, which I loved reading that about you. And since you gave me that, I thought, Anthony, we're going to put you on the spot and find out, as a legal advisor, what do you pride yourself in?
Sure. So first off, I'm a lot younger than Joe. I've been practicing for about 30 years now. I chair the firm's business services group. And my background is in financing and real estate development. I do pride myself in the ability to work with my clients. I was in-house counsel for several years for a real estate development firm, and I was their senior VP of business development. So I do pride myself in having the ability to step in my client's shoes and be able to understand the day-to-day operations as to what they're faced with, the challenges they're faced with as business entrepreneurs in the state.
I love that. That's beautiful. So ultimately, two people type of legal advisors we have here. And that's really important because a big part of what we're doing here, yes, we're giving a lot of business advice and looking at organizational resilience, but we always take a moment to look at personal preparedness and personal resilience and what that looks like. And so we welcome you guys. Thank you for joining us today.
Great to be here.
For having us.
So we're diving into looking at some of the legal issues around coronavirus. And one of the first things we wanted to talk about was, it's coming up for us in every episode, regardless of what the topic is, but the CARES Act and the Paycheck Protection Program has been just kind of the ongoing topic for the last month, it feels, because there are so many different pieces to look at and so many ways that we're seeing businesses being impacted. And the first thing we wanted to look at are some of the impacts from FAQ 31, certainty principle that was introduced around the Paycheck Protection Program. So one of the first thoughts we wanted to get from you guys, what are the ramifications to Treasury and SBA for companies who are now facing a situation where they have to pay back the funds that they received several weeks ago and have already used to bring back and pay employees? This clause has changed over time. What are the ramifications for that? And what liability do they have for making that change the weeks coming in so far?
Sure, Tashonda, I could take a shot at that. So initially when the guidance came out, when the CARES Act was enacted, the rules were that if your company faced uncertainty, economic uncertainty in today's times, and you felt that you needed financial assistance to carry the employees, that you had an opportunity to apply for PPP funds, right? And the goal of the PPP was certainly to make sure that employers keep employees retained, right? So if you had that economic uncertainty, that you made a good faith certification that you required the funds. When FAQ 31 was released in late April, they added a liquidity element. And basically FAQ 31 said that if the company had the financial resources, the liquidity to support ongoing operations without any substantial detriment to the operations of the company, then you may not necessarily have made your certification in good faith if that liquidity element. And that raised a host of questions for all these employers. What do they mean by liquidity? if you have a working capital line of credit, if you have, if you factor, and if you have an asset-based lending program where you factor your accounts receivables, if the individual owners are high net worth individuals, do they have an obligation to fund the company? So it became a sort of Pandora's box. And there's a lot of uncertainty around that. There was a safe harbor date of May 7th with respect to paying back the funds. If you took the funds, then FAQ 31's released, you could return the funds by May 7th, no questions asked. That date was recently extended to May 14th. So right now, the May 14th date is out there with respect to safe harbor. So I think to answer your question, if you hired employees, you rehired them, you took them off furlough, whatever you may have done because you had access to the funds, now you have to ask yourself, if you're returning those funds, what do I do with those employees? If you're asking yourself that question, I would think that's a good indication that you did take the funds in good faith. So I think, retaining the employees and then asking, the employer asks himself or herself, well, if I'm returning the funds, am I putting employees back on unemployment or furloughing employees? If you're going through that analysis, it's probably a good indication that you did take the funds in good faith. So
for those who are unsure, and I'm glad to hear about that extension, I just want a follow-up question with that about if you don't take advantage of the safe harbor option and you didn't do this in good faith, and maybe we don't know this yet, but what does it look like for those organizations? If you don't take advantage of the safe harbor option and you give the funds back and you find out later down the road, like I took advantage of the PPP and maybe I shouldn't, I thought I needed it. And what does it look like when we find out we didn't? What are the ramifications there? Do we even know that yet?
Sure. Alicia, do you want to say something on my earlier point?
Yeah, I was just going to say it's interesting, and we're hearing so much around this as well. But when this originally came out, they specifically lifted, the clause that said, related to having credit available elsewhere, and to Shonda's point, that was lifted, and now it's almost like they put that back in. So are they really able to do this? It's almost, if you will, like they're rewriting the law.
Yeah, and I agree with that, Alicia. To Shonda, in terms of your latter question, so if you took the funds, they introduced in all of this, there was an introduction of a audit for anybody. At least what we're told is that there will be an automatic audit for any borrower that has borrowed in $2 billion or more, right? So now they introduce this other element to give people pause for concern. But in terms of what would happen if you get caught up in an audit, you're in an audit mode. You have to have the proper backup with respect to how you made that certification, right? So even in FAQ 31, they give an example. And they say, what if I'm a company, a public company that has access to capital markets for funds? And in that case, they say if you get caught up in this audit, you have to justify your certification, right? So ultimately, if you committed a fraud, if you clearly committed a fraud under the statute, there's certainly exposure for criminal penalties and costs and things along those lines. But I think it's going to be a case-by-case analysis for every borrower using prudent business judgment discretion in terms of making this certification. So I think that's important. And also, it's important to recognize that the forgiveness will be made by the SBA lender. So the way the process is set up, you apply to your SBA lender, you get the approval, and then you get funded from the SBA lender. After 8 weeks, you go to the SBA lender, you ask for forgiveness. The SBA lender makes that determination, and then they go to the SBA to trigger the 100% guarantee of the forgiven amount, right? So to me, that's an important factor. If you get caught up in the audit, it looks like the audit will be done by the SBA. There was pushback to have the lenders do these audits, and these lenders were up in arms. They had their hands full processing these loans. Doesn't seem like they're making a lot of money off of them, but a lot of lenders are doing it to accommodate their existing customers. So in terms of the actual audit, though, it will be coming from the SBA.
Are they going to have a certain amount of time, do you know, to complete these audits?
I haven't seen any guidance on that. There's nothing that states that. There's no per se statute of limitations where they say that we need to complete the audits in 2-3 years. It's going to take a while, right? To the extent they complete them. I think there was close to 200 million individual loans made, $700 billion in PPP funds under the CARES Act. So if they're going to complete these audits anytime soon, even anytime soon, I think is years, in my opinion. So
I was going to say, do we know what they would even be auditing?
So I think the audit is going to be on the liquidity factor, right? Do you have a basis for a good faith certification that you require these funds for ongoing operations? So look, this came out when there was talk about a second tranche of funding, right? I think within a matter of 10 days, the first round of funding dried up. Then they were talking about introducing new funding, and you started hearing about horror stories with Shake Shack, Ruth Chris Steakhouse, all these large companies that were receiving these funds. So I think this has become more political hot potato to put a little fear in these borrowers to really make them rethink their position.
Yeah, and what I was going to add to that is, even though it's an automatic audit if you received a PPP loan in the amount of $2 million or above, that doesn't mean that you're off the hook if you got a PPP loan for under that. Similar to an IRS audit, I'm sure there's going to be random audits that are made of companies that received less than $2 million. So those companies also need to be very vigilant in determining that they can satisfy that liquidity requirement. And I'm sure that those audits are going to involve, similar to an IRS audit or any other governmental tax liability type of audit, that they're going to need to engage accounting professionals such as yourself and engage maybe different departments within accountants like Mazars and others to assist them in substantiating the good faith basis for their need for the PPP loan and for the fact that it was very necessary for them in order to continue their normal business operations and retain the employees that they had basically had on the books at the time.
It seems like it's very reminiscent of, and it's not to compare the current crisis to any crisis that we've experienced, in our lifetimes, but in the OR space and organizational resilience, we see this kind of thing in disasters a lot, where there is this big push of SBA funding that comes out to support different businesses. There's not quite enough oversight and accountability as far as what the considerations are and who you put in place for that in the beginning. And then everyone applies for this money because everyone thinks they're eligible. We look eligible. I'm eligible. You gave it to me. And then months down the road, as this evolves and the rules change, because we're starting to add in the oversight and accountability to the program, we see these businesses, many of whom probably really needed it. Like you said, Anthony, it's like, it's good. I did it in good faith. We were struggling. And we are learning this. It's CYA is so big during these crisis times when SBA funding comes out. Cover your audit. Can't say it enough. And I can't tell you how many organizations I saw in New York City post Sandy that, they got what they needed and they were surviving, but then the impacts of finding out you weren't eligible once they really worked out the kinks of the program, the impacts caused that organization not to be able to live on, years after this disaster's been done. And I thought I was okay. So it's just really unfortunate.
Yeah. That's why I'm curious too, with them coming out so late with this, and, specifically again, that, there was, where normally you would have the credit elsewhere, that was lifted specifically. So, to what extent are they liable? Because I would imagine that giving the funds back and, they were making business decisions based on the fact that they had received these funds for several weeks now, that, this could end up putting them under. And I think that, I don't know, I have not witnessed this before, but, I would have to imagine that there's going to be some companies that now this actually does negatively impact them, and that they are going to go and push back on this. And there's been a lot of FAQs, just sticking to the FAQs that have come out over the past several days. We're actually betting internally to what number are we going to get to before they put out the final guidance on this. But one came out specifically earlier this week that caused a lot of uproar as well. And that was around the foreign affiliates, and including now your global headcount when looking to, are you considered a small business as defined by the SBA? And I know, at Mazars, we're a global firm, and many of the companies that we represent have foreign affiliates. And, where previously we were looking just at U.S. heads, and they were, far and large small businesses, when considering global headcount, that's a game changer for them. And, they would have to give the money back as well. Do you guys have any thoughts on that, or what are you hearing in terms of that? It's another big change.
Yeah, so that's interesting, right? So the affiliation rules, the SBA affiliation rules apply in terms of headcount for the 500 maximum, and then there's exceptions to that based on sales and affiliations, net worth, and affiliations triggered with respect to common ownership and all these key. I think there's 4 key areas of affiliation. But yeah, so you have to now take into account the foreign affiliates. I don't know if that really changed anything. That was more of guidance saying that, yes, you have to take it into account. I didn't see anything beforehand that said, in terms of the affiliation rules, that the foreign affiliates should be excluded. But here is a little different than FAQ 31, because here there's no safe harbor date. So by the time this was released, most of these funds have been funded already, right? So there was another FAQ, and I believe it was FAQ 17, that says if you filed an application before the guidance was released, do you need to take any subsequent guidance into account? And the answer to that is no. You can rely on what was out there at the time you filed. So it's a little different in terms of releasing money, because they're not giving you an opportunity to refund the money. So at the time that if you relied on the certification and what your interpretation and your professional's interpretations of the rules were, then you're okay. I don't think this new FAQ 44 means that if you start looking at foreign affiliates, you need to return the money. Okay, so I think that's a little nuance that will be interesting to see how that plays out.
That's an interesting interpretation and helpful. Yeah, I know, in the initial guidance and what still is out there, it maybe is not entirely clear, and just alludes to that you should only include employees who reside, their principal residences within the U.S.
That's correct.
We'll see.
Well, this was by no means a lecture, but I do hope our listeners were taking notes on some of the best practices regarding these FAQs, because it can impact you if you're participating in the Paycheck Protection Program. And these are things to be considered for future programs that are coming down. We want to thank Anthony and Joe for joining us for our first chat on some of the legal impacts for businesses participating in these pandemic recovery initiatives. Thanks, guys. For more information on the topics discussed today, visit us at mazarsusa.com/COVID-19. That's MAZARsusa.com/COVID-19. Remember, all information shared on Mazars COVID Talks extends from reputable sources. The views expressed here are meant to serve as suggestive guidance based on the knowledge and expertise of the co-hosts and guests. Thank you.